Okay. So guarantee and suretyship is embodied in the civil code. Let me share screen to you our discussion for this evening. This would be from Article 2047 to Article 2048. All right. So what is guarantee? Under Article 2047, that is a contract whereby a person who is considered as the guarantor binds himself to the creditor to fulfill the obligation of the principal debtor in case the latter fails to do so. Okay, so it's a contract between the person who is the guarantor and with that of the principal, um, with that of the creditor. Okay, to be held answerable if the principal debtor would fail to do so. So maybe you are familiar with uh, bank loans or loan agreements wherein there is the debt, which is the principal obligation of the debtor to that of the creditor, and then there is an accessory contract on it, the contract of guarantee, wherein another person would be acting as a guarantor of that principal debtor. Okay, so it's a separate accessory contract. Okay, and the principal obligation, the principal contract is the contract of loan, and the contract of guarantee is between that person who is the guarantor and that of the creditor. Okay, that is a contract between the guarantor and the creditor. All right. So what are the classifications of the guarantee under the civil code? We have here personal and real. So when you say personal, that is a guarantee. The guarantee is the credit given to the person who guarantees the fulfillment of the principal obligation. Okay, so it's the personal credit character, the credit character of the person who is which is the basis of such guarantee. So that's what you call personnel. And the second classification, the broad sense, is the real, wherein the guarantee is property, whether it's a movable or immovable. Okay, so let's say it's a pledge or a mortgage. Okay, it's the property itself and not the person. As to the origin, guarantee could either be conventional, legal, or judicial. When it's conventional, means it's agreed upon by the parties. And if it is legal, that is one imposed by the virtue of a provision of the law. So most often than not, it's always conventional agreement. Okay, conventional agreement. And judicial is one which is required by the court to guarantee the eventual right of one of the parties in the case. So voluntary yung first classification, the second are the second and the third are involuntary. Okay. Now, as to consideration, generally, guarantee is gratuitous, meaning to say the guarantor does not receive any price or remuneration for acting as such. Okay, so when you say somebody lends his credit to somebody to be a guarantor of that principal debtor, okay, he don't receive any amount thereof. But sometimes there is also consideration. That's why it's called onerous. Okay, so if there's a consideration on the received by the guarantor, then it is onerous. As to the person guaranteed, it could either be single or double or sub-guarantee. So single is one constituted solely to guarantee or secure performance by the debtor of the principal debt, the principal obligation. Whereas a double guarantee or a double or sub guarantee is one solicited to secure the fulfillment of the by the guarantor of a prior guarantee. So it in double or sub guarantee, what is being guaranteed is the fulfillment of the obligation of a prior guarantor. So parang second level na siya. There's a principal obligation, there is a guarantor, and the guarantor itself is being guaranteed by somebody. That's why it's called double or sub guarantee. And lastly, as to the scope or extent of the guarantee, it could be classified into definite, wherein the guarantee is limited to the principal obligation only or to a specific portion thereof. And the other classification is indefinite, or one which not only includes the principal obligation, but also all its accessories, including judicial costs. Okay, so indefinite. So most often the common classification, the common guarantee that is being entered into is the definite, or that which is limited only to the principal obligation. Okay, now what is a surety? What is a suretyship on the other hand? Suretyship, it is more there's a bigger obligation, there's a bigger liability of a person who is acting as a surety. So what is a suretyship? It is a contract whereby a person, called a surety, binds himself solidarily with the principal debtor. Okay. So a relation which exists where one person, the principal, has undertaken an obligation and another person, called the surety, is also under a direct and primary obligation or other duty to the obligee. He is entitled to but one performance as between two who are bound. The second rather than the first should perform. Okay, so practically in suretyship, there is a contractual obligation resulting, uh, mean to say, the surety is also solidarily liable with that of the principal debtor. Unlike in guarantee that there is determination first to the principal debtor before the guarantor would become liable thereof. Okay? Wait lang. Sige, wait. So, uh, the definition of the surety is under the second paragraph of 2047. Okay, so if a person binds himself solidarily with the principal debtor, the provision this shall be called suretyship. Jessica adto ng food panda. Ada ubos. So in suretyship, there is but one contract. So the surety is bound by the same agreement which binds the principal. So it's practically between the the creditor and that of the principal plus the surety. Okay, so the surety here is usually bound with the principal by the same instrument. So executed at the same time or upon the same consideration in the case of Palmares versus CA. So there is no need of an accessory contract unlike that of a guaranteeship. Okay, so maybe you are familiar with like somebody would obtain a loan and then he would sign as a surety. So if he is a surety, the liability there is could either be the creditor could run after that surety even if the principal debtor is not yet determined to be not capable of paying. Okay, so um, practically, the liability of the surety is higher or bigger or more broader than that of a guarantor. Okay. Um, so sometimes you have to be very careful. Like if you want to act as somebody who wants just to guarantee the fulfillment of the obligation, you should look into the terms of the loan agreement if you are signing, let's say, as a co-borrower or as a surety or just a guarantor. Because in most instances, if it's just a guarantor, you will be held liable only if the principal debtor will not be able to fulfill his obligation. Okay, unlike suretyship, or if you're a co-borrower, the the liability there would be similar to that of the principal debtor. Okay, so it is not for the obligee to see to it that the principal debtor pays the debt or fulfill the contract, but for the surety that to see to it that the principal debtor pays or perform. Hello? Ah, sige, sige. Ayaw, di da checkpoint. Diri to the checkpoint. Ini nga may Goc-ong law office, may the adventure. Ini nga tulok andana. Sige. So, what is the nature of the suretyship's undertaking? First, the liability is contractual and accessory, but direct. Okay, so mean to say he is directly, primarily, and equally binds himself with the principal as an original promisor. Now, although he possessed no direct or personal interest over the latter's obligation, nor does he receives any benefit therefrom in the case of PNB versus CA. So also the liability limited only by the terms of the contract. Just ikato pan usa. Adi ha ubos, pagdalang kwarta liwat ha. Hello, Jess. Okay, to continue, the liability arises only if the principal debtor is held liable. Okay, now the creditor may sue separately or together the principal debtor and the surety. Where there are several sureties, the obligee may proceed against any one of them. Okay, any one of them. So later on, we will be discussing what would be the difference, how do we distinguish surety and guarantyship. Okay. Now, in most instances, the the primary distinction there is in guarantee, uh, there is several debts that the creditor are, I mean, the debt that the guarantor are jointly liable. I mean to say, if there are 5 guarantors or 4 guarantors, the guarantors will only be liable for 1/4. Whereas in suretyship, if there are 4 surety, the creditor or the obligee can proceed in any one of them for the full amount. Okay. Now, in the absence of collusion also, the surety is bound by a judgment against the principal, even though he was not a party to the proceeding. The nature of its undertaking makes it privy to all proceeding against its principal. So the case of Finman General Assurance Corporation versus Sally. Okay. Then another consideration in the liability or the nature of the suretyship's undertaking is that the surety is not entitled to benefit of exhaustion. So later, I will be discussing what is a benefit of exhaustion, or sometimes this is benefit of excusation. So this word has been asked in one of the recent excussion and exhaustion is also similar, are just similar terms. So it would mean that before in guarantee, before the guarantor would be held liable, there should be exhaustion of all possible remedies against the principal debtor first, before he will be held liable. But in suretyship, here, the surety is not entitled to that benefit of exhaustion. So, as long as the principal obligee had already been, if the principal debtor had already been deemed to be liable thereof, let's say the loan has already been due and demandable, his liability would also be due and demandable. So, he assumes a solidary liability for the fulfillment of the principal obligation as an original promisor or debtor from the beginning. Okay, so please take note of that one because it's one of the important concepts. Okay, concepts on suretyship. Also, the undertaking is to creditor and not to a debtor. The surety makes no covenant or agreement with the principal that if it will fulfill the obligation guaranteed for the benefit of the principal. So the such promise is not implied by law either, and this is true even when there is a contract. The creditor is given the right to sue the principal or the latter and the surety at the same time. Okay, so pareho silang be held solidarily liable. And since there is no benefit of exhaustion or benefit of excusation, the surety also is not entitled to notice of the principal's default. Unlike in guarantee that there should be notice of the principal debtor's default. So the creditor owes no duty of active diligence to take care of the interest of the surety, and the surety is bound to take notice of the principal's default and to perform the obligation. So he cannot complain that the creditor has not notified him in the absence of a special agreement to that effect. In the case of Palmares versus CA. So it will not be an excuse that the principal debtor has been in default before he would be held liable because it is not entitled to such benefit. Simply because he is solidarily liable as an original promisor. That's a surety. Also, prior demand by the creditor upon the principal is not required. So as soon as the principal is in default, the surety likewise is in default. So similar standing sila. Surety is also not exonerated by the neglect of the creditor to sue the principal. Okay, so those are the important points that you should consider in determining the surety's undertaking. Okay. Now, these two, the guarantee and suretyship, the similarities are the following. They are both accessory contract. Okay, they are both accessory contract. It is indispensable condition for its existence that there must be a principal obligation. So what is the principal obligation here? It is the loan agreement. Okay, it's the loan contract or the loan agreement between the debtor and the creditor. Now, guarantee may be constituted to guarantee the performance of a voidable or unenforceable contract. It may also guarantee a natural obligation. But the guarantor cannot bind himself for more than the principal debtor, and even if he does, his liability shall be reduced to the limits of that of the debtor. And both guarantee and suretyship has the characteristics of being a subsidiary and also conditional, wherein it takes effect only in case the principal debtor fails in his obligation. So the guarantor cannot bind himself for more than the principal debtor in the same provision. This Article 2054. Also, it is unilateral. It may be entered without the intervention of the principal debtor. Okay, nominate because they are given the specific name, which is guarantee and then suretyship. It's also consensual, mean to say it is perfected by the meeting of the minds of the parties. And okay, it is a contract between the guarantor and the creditor, or the surety and the creditor. What else are the characteristics? In guarantee is not presumed. Okay, it must be expressed and reduced into writing. Now, a power of attorney to loan money does not authorize the agent to make the principal liable as a surety for the payment of a debt of a third person. It must be specific. It must be reduced into writing that one can enter into as a guarantor or as a suretyship. It also falls under the statute of frauds since it is a special promise to answer for the debt, default, or miscarriage of another. And as to interpretation, the rule of strictissimi juris is being applied. So it's strictly interpreted against the creditor and in favor of the guarantor or the suretyship. And it is not to be extended beyond its terms or specified limits. So in the case of Palmares again versus CA, the rule will apply only after it has been definitely ascertained that the contract is one of a suretyship or guarantee. So it cannot be used as an aid in determining whether the party's undertaking is that of a guarantor or a suretyship. So kailangan very, very plain and simple that he is acting as a suretyship or is acting as a guarantor. Okay, it does not apply also in cases of compensated suretyship. So what is the distinction given all those classifications, characteristics, and important points in surety? How are we going to distinguish guarantee and suretyship? So first, okay, I sum it up. I've summed it up into this 6 distinction. For guarantee, the liability depends upon the independent agreement to pay the obligation if the primary debtor fails to do so. Whereas in surety, the suretyship, the surety assumes liability as a regular party to the undertaking. Take note, he is a regular party to the undertaking. In guarantee, the second distinction, it is collateral undertaking, whereas in suretyship, the surety is an original promisor. Okay, so please take note of those important distinctions. Third, the guarantor is secondarily liable, surety is primarily liable. Diba? Kasi nakalagay doon, diba, he is treated as a uh, original promisor. So he is solidarily liable with that of the principal debtor. Then fourth distinction, the guarantor binds himself to pay if the principal cannot pay. Cannot pay. So the word is cannot pay. There is a benefit of exclusion. It should be determined that really the principal debtor cannot really have the capacity to pay anymore. So bankrupt na siya or insolvent. Whereas in suretyship, the surety undertakes to pay if the principal does not pay. Once it falls due, he did not pay, he's already in default, the suretyship will be held answerable right away. So even if he has still capacity, as long as he becomes in default, he would still be held liable. Okay. Fifth, a guarantee is an insurer of solvency of the debtor. Solvency of the debtor, whereas surety, it is insurer of the debt itself. Okay, so walang solvency issues. The number 6, the guarantor can avail of the benefit of exclusion and division in case the creditor proceeds against him. Meaning to say, yung division, the benefit of division, if there are 2 or more guarantor, he will only be liable to his proportionate share. Whereas a surety cannot avail of the benefit of exclusion and division. So even if there are 2 or more sureties, each surety can be held liable for the entire liability. The creditor can just run after one surety to have them pay the entire liability, the entire debt. Okay. Distinction between endorsement and guarantee. So endorsement is primarily of transfer, whereas a guarantee is a contract of security. So endorsement, this is similar to that of endorser in a negotiable instruments. Now, unless the note is promptly presented for payment at maturity and due notice this honor has been given to the endorser within a reasonable time, he will be discharged absolutely from all the liability, whether he has suffered any actual damage or not. So, endorsement is on negotiable instruments law, wherein the endorser he would also be held liable. Okay. Now, there's a distinction. The endorser does not warrant the solvency, but a guarantor warrants the solvency of the promisor. So the endorser can be sued as a promisor and the guarantor cannot be sued as a promisor. Now, how about the distinction between a guarantee and a warranty? So, parang magkapareho but it's two different it there are two different legal concepts. So what is a warranty and what is a guarantee? So the distinction is in a guarantee, it's a contract by which a person is bound to another for the fulfillment of a promise or engagement of a third party. While a warranty is an undertaking that the title, quality, or quantity of the subject matter of the contract is what it has been represented to be and relates to some agreement made ordinarily by the party who makes the warranty. So you say warranty, let's say you buy a cell phone, okay, a brand new cell phone, and then the manufacturer, or let's say the supplier of that warrants that it is of the same of a particular quality, particular quantity, and if there is breach of warranty, you can return the goods, you can return the item. So it's on particularly on a particular subject matter, and it relates also to agreement ordinarily by the party who makes the warranty. Okay, so it's different from that of a guarantee kasi pag sa guarantee, it's the fulfillment or of a promise or engagement that is being assured. Okay, it is being guaranteed. All right, so let's continue. Article 2047, guarantee is gratuitous unless there is a stipulation to the contrary. That's why I told a while ago, the classification, most often than not, guarantee is always gratuitous. This by virtue of 2048, Article 2048. Okay, the peculiar nature of the guarantee or surety that it is regarded as valid despite the absence of any direct consideration received by the guarantor or surety, either from the principal debtor or from the consideration, or from the creditor. So a consideration moving to the principal alone will suffice. So it is never necessary that the guarantor or surety should receive any part or benefit if such be accruing to the principal. So kasi nga, gratuitous, generally gratuitous. But if there is a stipulation to the contrary that it is subject to a consideration, then it becomes an onerous. Okay? Now take note also that a married woman may guarantee an obligation without the husband's consent, but shall not thereby bind the conjugal partnership. So, kailangan if becomes a guarantor, he should there is if it pertains to a property that is being used as a real guarantee, then there is a consent of the spouse, the other spouse. 2051 is actually the provision on double or sub guarantee. Okay, it says here a guarantee may be conventional, legal, gratuitous, or onerous, and it may be constituted not only in favor of the principal debtor but also in favor of other guarantor. So if it is constituted to guarantee the obligation of a guarantor, it becomes a double or sub guarantee as embodied under Article 2051 of the Civil Code. 2053 is a continuing guarantee. So it's another kind of guarantee wherein it is may be given as a security for future debts. So future debts, Article 2053, the amount of which is not yet known. So that's why it's called continuing let's say there is a loan agreement of a particular person with a bank. He has a credit line, let's say of 10, let's say of a 50 million, and from time to time he would borrow money from the bank. And then as a accessory contract to it, there is a contract of guarantee between the bank also and the guarantor, that he will act as a guarantee in the subsequent loan transactions. Okay, so whether the amount is not yet been determined, he agreed to be as a guarantor of such future debts. Okay, so it is one which is not only limited to a single transaction, but which contemplates a future course of dealings. So covering a series of transactions, generally for an indefinite time or until revoked. So um, ito usually kasi pag your credit standing is very good in the community, the credit standing is practically known in the community to be that clean. So there is a continuing guarantee that is being entered into. So that's Article 2053. So it will become valid until it is revoked. So there is a prospectivity. So it is prospective in nature, and it is continuing when the terms thereof is if it's evident that the object is to give a standing credit to the principal debtor. Okay, a standing credit to the principal debtor to be used from time to time, either indefinitely or until a certain period, especially if the right to recall the guarantee is expressly reserved. Okay, so future debts, what are future debts? This may refer to debts existing at the time of the constitution of the guarantee, but the amount thereof is unknown, and not to debts not yet incurred or existing at that time. Okay, so hindi pa siya, that the amount is not yet known. So exceptions to the concept of continuing guarantee is a chattel mortgage, because a chattel mortgage can only be constituted later on if we discuss mortgage and pledge. You will know that a chattel mortgage can only cover one obligation existing at the time of the mortgage, and it cannot be done on future debts. Okay, unlike guarantee, there could be a continuing guarantee. Okay, standing credit to the principal. Article 2055, the extent of the guarantor's liability. So it says here that where the guarantee is definite, it is limited in whole or in part of the principal debt to the exclusion of the accessories. Okay, this spells out the distinction between that of a surety. At ito, limited only in whole or in part of the principal debt to the exclusion of the accessories. But that's if that guarantee is definite was classification could also be definite or indefinite. Now if the classification if the guarantee is definite or indefinite or simple, it shall comprise not only the principal obligation but all its accessories, including the judicial costs provided with respect to the other. The guarantor shall also be liable for the costs incurred after he has been judicially required to pay. Okay? So, what are the classifications of a guarantor? When can you be qualified to become a guarantor? Article 2056 to Article 2057 provides that a guarantor, one who is obliged to furnish a guarantor, shall present a person who possesses integrity, capacity to bind himself, and sufficient property to answer the obligation which he guarantees. Okay, so the creditor, usually banks or cannot accept a guarantor na also a broke person or um, insolvent or known in the community to be also um, lubog sa mga debts. Okay? So once there is a contract of guarantee, the guarantor is presumed to have integrity, mean to say he will be true to his words that he will pay the obligation of the principal debtor once he fails to do so. Also, he has the capacity to bind himself. So he is not incapacitated, he is not insane or demented person. So meron siyang capacity to enter into contract or to bind himself. And of course, yun, he has sufficient property to answer the obligation. So the qualifications need only be present at the time of the perfection of the contract. Now, the subsequent loss of integrity or property or supervening incapacity of the guarantor would not operate to exonerate the guarantor or the eventual liability he has contracted. So the contract of guarantee shall continue. So kailangan lang at the time of the perfection, he has all that qualifications. Otherwise, sa start pa lang, if he don't have this qualification as embodied under Article 2056 and 2057, he will not be qualified to be acting as a guarantor. Now, however, and if there are supervening events or subsequent loss of integrity or property, the creditor may demand another guarantor with the proper qualifications, or he may waive it as if he chooses or hold the guarantor to his bargain. Okay? Now, ito yung famous na benefit of exclusion. When you say I said it's famous because it was asked in one of the bar exams, just a recent bar exam. A very simple, what is the principle of the benefit of exclusion? So, most barristers were not able to answer that kasi hindi nila malaman kung saan nila nakabasa yung benefit of exclusion. So this benefit of exclusion or exhaustion are the same, is actually Article 2058 of the Civil Code. Okay, so please take note of this one. It is the right by which the guarantor cannot be compelled to pay the creditor unless the latter has exhausted all the properties of the principal debtor or has resorted to all legal remedies against such debtor. So it's a right, it's a benefit granted to the guarantor. Okay, so he has the benefit and he cannot be held or cannot be compelled to pay unless the creditor would exhaust all the properties of the principal debtor or the creditor has resorted all legal remedies against the debtor. So meaning to say, meron na siyang notice, meron na siyang exhaustion, just like your principle in your administrative law, di ba? Exhaustion of administrative remedies, di ba? You cannot sue a person in court unless you have exhausted all the administrative remedies. So in guarantee, in the concept of guarantee also, you cannot compel the guarantor to pay unless you have exhausted all the properties and all the legal remedies against the principal debtor. Okay, so that's Article 2058. Now, take note that this benefit of exclusion or benefit of exhaustion is not applicable to a contract of suretyship. Okay, that's Article 2047. And it cannot even begin to take place before the judgment has been obtained against the debtor. So, it's only applicable to a contract of guarantee. Now, would there be instances that there is no, that the guarantor is not given the right of exhaustion? Okay, the answer is yes. Okay, there are instances that exclusion shall not take place as embodied under Article 2059. Okay, Article 2059. Ito. If it may be presumed that the execution of the property of the principal debtor would not result in the satisfaction of the obligation. So, no more benefit of exclusion. So, kita pa lang, wala na talagang broke na talaga yung principal debtor or is already been bankrupt or insolvent. So, no more benefit of exclusion if it is presumed that the execution of the property would result in satisfaction. Or when he has absconded or cannot be sued in the Philippines unless he has left a manager or representative. Or in case of insolvency of the debtor, there must be an actual insolvency. So, mean to say, has been adjudged to have been insolvent. So, meron siyang insolvency proceeding. And if the guarantor also expressly renounce it, so if he waives it, that's Article 2059. Or if he bounds himself solidarily with the debtor. So, no more benefit of exclusion because by this time, if he bonds himself solidarily with a debtor, he becomes a surety, and no longer a guarantor. Okay? So that's Article 2059. Now, in addition to that, the benefit of exclusion is also not available or the guarantor is not entitled if he is a judicial bondsman or subsurety. Okay. It's not a guarantor but a judicial bondsman. Or if he fails to interpose it as a defense before judgment is rendered against him. So there's also no benefit of exclusion. Or if the guarantor does not set up the benefit against the creditor upon the latter's demand for payment from him, point out to the creditor available property to the debtor within the Philippines sufficient to cover the amount of debt. Okay, so kailangan there is also sufficient consideration to be given to the creditor or where the pledge or mortgage has been given to him as a special security. Because if there is already a real guarantee, that particular mortgage or pledge shall be used to satisfy the principal obligation. And then you have your Article 2065. 2065 is the principle of benefit of division. Benefit of division. So, ano naman itong benefit of division among, there are several guarantors, only one debtor, for only one debtor and the same debt, the obligation to answer for the same is divided among all. It's what that I mentioned a while ago. Let's say the amount of the principal debtor is 10 million and there are 4 guarantors. The guarantor 1 will only be held liable for 1/4 or 25 million. Okay. 2.5 million kung 10 million, 2.5 million. So meaning to say, in a contract of guarantee, the guarantor's liability is joint. Diba? When you say joint, there are as many debtors as there are many debts. Okay? Even if there are several guarantors and only one debtor, the guarantor's liability is joint. It shall be divided among all the guarantors. Right? Kasi mamaya, pag sa surety, wala siya. Wala siyang benefit of division. This pertains only to guarantor of a guarantee, in a contract of guarantee. Now, important to consider also are the provisions on 2073, 2059. Now, the creditor can claim from the guarantors only the shares they are respectively bound to pay, except when the solidarity is stipulated if any circumstances. That's 2059. Or the right of contribution of the guarantors who pays requires the payment must have been made by virtue of a judicial demand or because the principal debtor is insolvent. Because you will learn later on that if the guarant one of the guarantor would pay uh, higher than that in which he is liable, it cannot be refunded. Okay, unless there is a express stipulation. Okay, so if any of the guarantors should be insolvent, his share shall be borne by the others. And yon, the right to contribution or reimbursement by its co-guarantor is acquired ipso jure by virtue of said payment without the need of obtaining from the creditor of any prior cessions of rights. Okay, so a co-guarantor may set up against the one who paid. Okay. 2062 of the Civil Code pertains to the procedure when the creditor would sue. So the creditor must sue the principal, and the guarantor cannot be sued with the principal, much less alone. So mean to say, kailangan i-sue muna yung principal obligation, and they cannot be sued simultaneously. Right? Notice to the guarantor of the action. The guarantor must be notified so that he may appear. If he so desires, set up the defense he may want to offer. And the guarantor cannot, if the guarantor appears, he is still given the benefit of exhaustion, even if the judgment should be rendered against him and the principal debtor. So the guarantor is entitled to be heard before the execution can be issued against him, where he is not a party in a case involving his principal. So there is the procedure, and there is that due process being given to the guarantor before he will be held liable. All right, 2066 on the other hand is the guarantor's right of indemnity or reimbursement. Okay, so guarantee is a contract of indemnity. So he will reimburse, of course, the one who benefited by the payment. So it doesn't necessarily mean that pag makabayad na si wala na, as if he is already the one who benefited from the loan. So it's a contract of indemnity. So the guarantor who makes the payment is entitled to be reimbursed by the principal debtor. Okay, that's Article 2066. Okay, so what are the indemnity? What would the indemnity comprise? So Article 2066, second paragraph, would give you the information of what would it consist, the indemnity, kung ano yung i-reimburse kay guarantors. Of course, first, the total amount of the debt. Second, the legal interest thereon from the time the payment was made. Okay, there's a notice of payment. Third, the expenses incurred by the guarantor after having notified the debt that payment has been made in a consequence. And if there are damages, if they are due in accordance with the law. So, what may damages? If they are due. Exceptions: when the guarantee is constituted without the knowledge or against the will of the principal debtor, the guarantor can recover only insofar as the payment has been beneficial to the debtor. So that's Article 2053. Or if the payment by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation. Pag binayaran lang niya without any intention of being reimbursed, it's practically a donation by that third person, okay, to the debtor. If there is a waiver of the right of demand to demand reimbursement. Okay? Moving on, don't worry, konti na lang to. Guarantor's right to subrogation. So, 2067 pertains to the guarantor's right of subrogation. Now, a guarantor who pays is subrogated by the virtue thereof of all the rights which the creditor had against the debtor. So, parang ano na siya, he is placed into the shoes of the creditor once he paid. So, what is subrogation? Subrogation transfers to the person subrogated the credit with all the rights thereto appertaining either against the debtor or against the third person, be they guarantors or possessors of mortgages subject to stipulation in conventional subrogation. So here, there is the operation of the principle of subrogation. So the right of subrogation. So the right of subrogation is necessary to enable the guarantor to enforce the indemnity given in Article 2066. Kasi pag wala siyang right of subrogation, how can he recover the amount paid? How can he recover the expenses incurred and also the damages? So it arises by operation of law upon payment by the guarantor. So by virtue of this provision, 2066 and 27, it automatically gives the guarantor the right of subrogation. So it is not necessary that the creditor cede to the guarantor the former's right against the debtor. Hindi na kailangan. Kasi automatic na siya. So it is not a contractual right. The right of the guarantor has paid the debt to subrogation that does not stand upon the contract but with the principle of justice. Okay? Moving on, Article 2068. If the guarantor pays without notifying the debtor, what will happen? It says here that if he pays, the latter, meaning the debtor, may enforce against him all defenses we could have set up against the creditor at the time the payment was made. So the debtor may interpose against the guarantor those defenses. Okay, the debtor can even set up the defense of extinguishment of the obligation. So the same defense kasi 'di ba subrogated na si guarantor with the right of a creditor, but the debtor also, if there is payment without notice to the debtor, pwede niyang iset up yung kaniyang any defense he has against the creditor. So for example, meron pala silang uh, novation, or there was already cancellation of debt, or there was already uh, compensation, mean to say in-offset nila yung kanilang loan. And then the guarantor paid even without notice. So the debtor can set up that defense of previous extinguishment. But that provision here, okay, so under Article 2069, if the debt was for a certain period and the guarantor paid before it becomes due, what will happen naman? He is not entitled to reimbursement unless the payment was made with a consent or has been ratified. So it is as if he is given the blame here. Why would you pay when it is not yet due and demandable? So is not entitled to reimbursement unless yun ira-ratify or i-approve ng principal debtor. Now, if the payment has already made by the guarantor and then another payment was made by the debtor, what will be the rule? Okay, Article 27P provides the general rule: before the guarantor pays the creditor, he must first notify the debtor. Diba? That's the general rule under Article 2068. Kailangan may notice. Otherwise, diba, he cannot if the debtor would pay, the guarantor can only collect from the creditor and guarantor has no cause of action against the debtor. Okay, for example, hindi niya notify yung principal debtor, and then the creditor collects the money from the guarantor and then later on collects again from the debtor. So who will be entitled to reimbursement? Of course, the guarantor will be entitled to the reimbursement kasi hindi naman niya dapat binayaran in the first place. Now, but his cause of action would be against the creditor. Okay, the creditor. Kasi the creditor received double, di ba? Applying the principle of solutio in debite, cannot enrich himself at the expense of another. So the cause of action is not against the original debtor simply because he did not notify before payment. Okay? Now, exceptions, the guarantor can still claim reimbursement from the debtor in spite of lack of notice if the following conditions are present. Okay, it is still under Article 2070. First, the guarantor was prevented by fortuitous event to advise the debtor of the payment, and the creditor becomes insolvent, and the guarantee is gratuitous. Okay, so he can still claim reimbursement if those circumstances would arise. Okay? All right. So Article 2071, on the other hand, is another important provision on the right of the guarantor to proceed against the debtor before payment. So general rule, the guarantor has no cause of action against the debtor until after the former has paid the obligation. But in Article 2071, these are the instances that the guarantor, even before having paid, may still proceed against the principal debtor. So what are these exceptions? So there are 7. You just go over that, or let's just try to get over. When he is sued for the payment, syempre, pag he nasu na siya, you should have may proceed against the principal debtor kasi he's also been sued already. So in case of insolvency of the principal debtor, so when the debtor has bound himself to relieve him of the guarantee, and yon, 7, ano yan, 7 circumstances. Okay? So Article 2071 is applicable and available also to surety. Itong 2071. The instances wherein the guarantor or the surety may proceed even before payment, proceed against the principal. Article 2066, in contrast with 2071, so 2066, this provides for the enforcement of the right of the guarantor against the debtor after he has paid. Whereas in 2071, this provides for the protection before he has paid but after he has become liable. So it gives a right of action against after payment. Ito dito naman, protective remedy. Or this one is a substantive right because it's after payment, but this one is a preliminary in 2071. Okay, so take note also of that distinction. All right, let's go to extinguishment of a guarantee. What are the modes of extinguishing the guarantee? It's Article 2078, 77, 28, 79, and 2080. Okay, 76, actually from start of 76. Okay, um, the guarantee is being an accessory subsidiary is also terminated when the principal obligation is extinguished. So, kung ano yung mga modes of extinguishing the principal obligation would also apply to the extinguishment of the guarantee. For example, ano yung mga modes of extinguishing in your study of your obligations and contracts? Payment or performance, loss of the thing due, condonation or remission of the debt, confusion or merger of the rights of the creditor and the debtor, compensation, and novation. So those modes of extinguishing obligation of the principal obligation would also extinguish the guarantee, it being a accessory or subsidiary contract. Okay, but peculiar to this guarantee are the provisions as embodied under Article 2078, 79, 80, and 81. Yeah, 80. Okay, so Article 2078, the release in favor of one of the guarantors without the consent of the others benefits all to the extent of the share of the guarantor to whom it has been guaranteed. Okay, so release of one is also without the consent of the others benefits all. So pag ma-release without the consent of the others, the entire guarantee is extinguished. Okay? So for example, G, H, and I are guarantors for the debt of let's say 10 million. If G is released without the consent of H and I, then H and I will each be liable for only 1/3. Okay, benefited to the extent of the release of the other. Okay, so to the extent benefits all to the extent of the share of the guarantor to whom it has been guaranteed. Okay, so kumbaga 2/3 na lang yung kanilang magiging liability kasi it shall benefit the extent of the others. Then, another mode of extinguishing peculiar to guarantee if the creditor voluntarily accepts immovable or other properties in payment of a debt. Even if he should afterwards lose the same through eviction or conveyance of the property. That's Article 2077. Okay, so the creditor voluntarily accepts immovable properties. So, kumbaga, meron na silang modes of extinguishing. So, anong tawag dito? Hindi siya payment, di ba? Compensation or novation. Okay? Novation of the, kasi he accept the payment of the principal obligation by receiving a immovable or property. Then, also under Article 2080, whenever by some act of the creditor, the guarantors, even though they are solidarily liable, cannot be subrogated to the rights of mortgages or preference to the former. Okay? Or for some other causes of actions or when the principal obligation is extinguished. So, kasi nga, accessory contract, the principal is extinguished, the same should also be extinguished. And under Article 2079, if there's an extension granted to the debtor by the creditor without the consent of the guarantor, it will extinguish the guarantee. Okay? Will extinguish the guarantee. That's Article 2079. Basta take note without the consent of the guarantor. Kasi nga, specific lang yung kanyang liability only for a particular. If it is extended, hindi automatic yung extension ng guarantee. It should be with the conformity of the guarantor. Okay? So those are the modes of extinguishing guarantee and suretyship. Now, on bonds and legal and judicial bonds, Article 2082 provides that bondsman is a surety offered in virtue of a provision of a law or judicial order. He must have the qualifications required of a guarantor in a special law, like the rules of court. So, bondsman. So, usually, di ba may mga judicial bonds, or when you say bond, it is an undertaking that is sufficiently secured and not cash or currency. So, commonly understood to mean an undertaking that is sufficiently secured. So, a bondsman who has offered a virtue of a provision of a law shall have the qualifications of that of a guarantor and a surety. So, a bondsman is actually a surety. Okay? That's Article 2082. Now, 2083 provides that if a person required to give a judicial or legal bond should not be able to do so, a pledge or sufficient or mortgage sufficient to cover the obligation shall be admitted in lieu thereof. That's 2062. So pledge and mortgage can be submitted in lieu of the bonds. Now, the judicial bondsman and the subsurety are not entitled to the benefit of exclusion because they are not mere guarantors, but they are sureties whose liability is primary and solidary. So that's Article 2084. So their liability is that of a principal debtor. So walang benefit of exclusion, cannot demand exhaustion of the property of the principal debtor. So Article 2083. All right. I think you should stop up to that point. Share screen. Stop recording.